I'll try to make the file available later on. It'll be a very large file, and sometimes that has trouble being emailed or setting up, but I'll do what I can to make it available for other people. Two, you should know that even though this says UALR on the link, I have nothing to do with UALR, and none of my opinions reflect any of the opinions of that institution. I'm required to say that. And three, it's going to be hard for me to manage chat. I see my good friend, Professor Kane, is on. And if he wouldn't mind monitoring the chat and then every so often letting me know if there's common questions, I would really appreciate that.
Okay.
All right, thank you. All right, so let me put this in some context and kind of tell you what I want to do and then leave time for our conversation. Obviously, the big news today is the Dobbs opinion overruling Roe versus Wade. It's no surprise since we saw the draft opinion a few months ago. I want to talk about that opinion a little bit, but I also want to put it into context with yesterday's gun decision, because they share a lot of similarity in method, if not an outcome. And I think they both show how radical this Supreme Court really is. And then kind of put those two together at the end and maybe project what I think might be going on. Okay? So first, we saw the draft opinion of Dobbs several months ago. Today's opinion is the same in substance. It's a little different in tone, but it's essentially the same reasoning and essentially the same, it is identically the same outcome. The difference in tone is that whereas the draft opinion felt to a lot of people very snarky and hostile, this is a little more polite. Not much, but a little more polite. But again, the reasoning is identical. The conclusion is the same. And so any differences are just differences in style as far as I can tell. Now, all the opinions and the appendices are 213 pages. So I've done my best to digest that much information in a short period of time, but there's a lot in there. And so a lot of what I'm going to say really isn't going to talk about some of the kind of both interesting and very important positions the court takes about overruling prior cases. But I can mention that a little bit. Okay. So what I want to do is then begin to talk about Roe. Talk about the Dobbs case and briefly outline what it said and how it reached its conclusion, and then talk a little about the implications of that. And then I'll flip to the gun case and show you the similarities. Okay. So in Dobbs, the court concludes that there's no right to an abortion protected by the Constitution. At least there's no fundamental right to an abortion protected by the Constitution. And that distinction is important because it's the difference between giving a right some kind of insulation from the ordinary methods of politics and not. For you law people, it's the difference between strict or intermediate scrutiny and rational basis. And for the non-law people, rational basis pretty much means the government always wins. And strict scrutiny means the government almost always loses. And in today's opinion, the court says there's no fundamental right, and any regulations of abortion are tested or will be in the future tested by rational basis. So essentially, then states have free rein to limit abortion. Maybe not entirely, but they do have almost entirely their discretion. So how do they reach this conclusion? First of all, they have to overrule Roe and Casey. And they do so by declaring that Roe and Casey were egregiously wrong when they were decided. And they go through a number of things. The reasoning was bad, It's never been accepted. There's a lot of criticism. It's not a workable standard. It mischaracterized the nature of the right. You do all those things to reach a conclusion that Roe and Casey should be overruled. So that's the first step. Second step, then they say, so what's a fundamental right? And is the right to an abortion one of those? Just by comparison, the court has in the past held that there are fundamental rights to things like interstate travel, marriage, procreation, contraception, family issues, other things. So here the court says a fundamental right is a right that is deeply rooted in the nation's history and tradition. So then they go back and they canvass history and tradition. And they go all the way back to pre-revolution England. And their conclusion, after looking at all of this material, it's a long, long section, is that the right to an abortion was never deeply rooted. And the court says, gee, up until Roe versus Wade, most jurisdictions criminalized abortion. Therefore, it's not deeply rooted. Therefore, it's not a fundamental right. Now, the three dissenters criticize that. And they have their own very long section on history. And I guess the best you can say right now, I'll leave it at this and then comment on that later, is that at the very least, the history is controverted. That is, there are reasonable interpretations of history that can allow you to reach either conclusion. That reminds me of the discussion in Brown versus Board of Education, where the court at that time said, it's important to know what the framers of the 14th Amendment thought about segregated public education, but it's not clear what they thought. And so we're just going to punt on that and decide it on basic principles. Here, the majority chooses the history and the conclusion that leads to it saying abortion is not a fundamental right. So history and tradition are the key. And therefore, not only was Roe and Casey wrongly decided, but that they were wrong as a matter of constitutional law. And going forward, there's only rational basis protection for the right to an abortion. Okay. Now, that's essentially it. The court spends a lot of time justifying overruling Roe and explaining history, but they also spend a fair amount of time saying, well, this case really doesn't apply to other rights. This case really doesn't apply to other fundamental rights. Well, the problem with that is that the logic the court uses is fundamental rights can only be deeply rooted in history and tradition would apply to a host of other rights that are not mentioned in the Constitution, but are protected as fundamental. And that's the right to marriage, the right to same-sex or any sexual intimacy, the right to same-sex marriage, the right to contraception, the right not to be sterilized, the right to raise your children. There's a whole host of these rights that aren't mentioned in the Constitution, but don't have a deep history and tradition of being allowed. And just take interracial marriage, for example. Up until Loving versus Virginia in the late 60s, many states banned interracial marriage, and that was a consistent history. And they did so before the 14th Amendment and after the 14th Amendment, which had its equal protection clause. So by that same logic, Loving versus Virginia is wrongly decided because interracial marriage was not deeply rooted in history and tradition. And therefore, as the court did say in Dobbs, the states are free to do what they want, that we're returning it to the states. And that's not only true for interracial marriage, but it's also true, as I said, for contraception, Griswold versus Connecticut for sexual intimacy, Lawrence versus Texas for same-sex marriage, Obergefell. And so even though the court several times in its majority opinion and Justice Kavanaugh in his concurring opinion say, oh no, this has nothing to do with any of those other rights, you shouldn't believe them because their logic has to apply to these others. And the dissent was especially critical on that point. And the dissent said, essentially, you can't have it both ways. Either the majority opinion is hypocrisy, their words, or these rights are in question and threatened. But the dissent says you just can't have it both ways. Now, the majority says, well, abortion's different because abortion deals with an independent right, that is the right of the fetus, and therefore it's not like all these others. Well, of course, but saying something is different and saying something is different enough to make a difference are two different things. So again, you shouldn't be lulled into complacency by thinking, well, the majority said these didn't apply, because it does. And just to make that point even clearer, Justice Thomas, in a concurring opinion where he says, I agree with everything they said, but I just want you to know that the logic of this applies to all these other rights. And it's time for us to reconsider all of them. Because if this thing, the technical term is substantive due process, this notion about fundamental rights, if it's a problem in Roe, Justice Thomas says, it's a problem in all these other cases. Therefore, we shouldn't repeat our mistake there too. We should reconsider them all. And then, of course, he says, well, that doesn't mean we come at it differently. We might find a different location for them, but we need to do that. And so it's pretty clear that both logic and the way the court is going, those rights are in question. Now, the dissent, I think, really doesn't hold back. And it's worth an interesting read. And the dissent reads like it's a shadow majority opinion in parts. There's a lot of criticism of the majority, but they do their own analysis, right? They do their own historical analysis. And they also point out how there was nothing wrong with Roe and Casey in terms of the usual way that courts overrule prior cases. And certainly there's nothing wrong with Roe and Casey to the extent that, say, Plessy versus Ferguson, which upheld racial segregation, was wrong at all times. So again, the dissent does a very good job of analyzing all of that, a lot of technical stuff. But again, they don't hold back in their criticisms where they say things like the majority is hypocrisy and on the history. Now, the one thing that Justice Thomas didn't include in his list of cases that are not, that have to be reconsidered would be Loving versus Virginia, the case that struck down laws regulating interracial marriage. And we're all familiar with Ginny Thomas. So all that to say, all that's on the agenda for the future. Now, a couple related issues. Going forward, what does it mean? Well, in a state like Arkansas, which has a trigger law, abortion will be banned in all instances with two exceptions. As soon as the Attorney General certifies that this decision came out. So that could happen anytime. And the two exceptions in the law would allow abortions in cases of medical emergency. And a medical emergency is defined in ways that relate to the physical health of the pregnant woman. Okay? So it's a narrower description of medical emergency than other cases. And the other thing it says is the definition of emergency doesn't apply to what would commonly be called Plan B contraception. Doesn't apply to those situations before the normal way that a pregnancy could be determined. And so the morning after pill, Plan B contraception, it's not covered by this Arkansas trigger law yet, but that could change. So again, that could happen immediately. 26 states within weeks will have banned abortion through a variety of these trigger laws. 24 states will not. Second point to consider is if states attempt to regulate what their own citizens can do in other states. It's called extraterritoriality. And Justice Kavanaugh says he doesn't think that's a problem because that would penalize the right to travel. Now, if the court applies its prior decisions, I think they're right on that. Again, there's no telling if they would actually apply that decision in a way that would guarantee that. I've also mentioned before, and I think the law people will cringe when I say this, I think the Dormant Commerce Clause also would be a limitation there. So those two things may limit out of state or extraterritorial reach. The other thing would be relating to, say, preventing the importation of, say, abortion pills or other abortifacients into the state. That is a complex federalism question. I see that Merrick Garland just said states could not ban that. We'll see what happens. Again, Congress could specifically authorize states to ban the importation of those pills. Okay. JC. Yes.
I had a question about, one second, I think I froze. Oh, okay, I'm back.
Okay.
I had a question about the distinction between the morning after pill and an abortion pill, because I feel like there's a huge issue with people understanding that they're not the same thing, because the morning after pill is essentially like taking 4 regular birth control pills to stop ovulation. And if ovulation has already happened, the Plan B pill will not abort any conception that happens. And so do you feel like there's a good understanding of the difference between, like an 8-week abortion pill and the morning after pill with lawmakers?
So JC, when you say a good understanding, you mean among the general public, among lawmakers? What do you mean?
With lawmakers, because with the general public, I feel like they have no idea the difference between the two.
Well, that's an easier question, actually, because I think among lawmakers who are inclined to ban abortion, it doesn't make any difference. And I expect in the next session of the General Assembly, they will rewrite that exception in our trigger bill to ban whatever you call it, both say 8-week mephistophorone, I think that's how you pronounce it, and the Plan B contraception. Because in their mind, right, it's a living being at conception. Therefore, you can't stop it at any time.
Right. And see, that was my question, because, if contraception is still going to be allowed, then the Plan B should still be allowed, because if it has already, actually implanted,
Sure.
It won't work. It's not, once there's conception, the Plan B pill won't do anything. And so if it's a major inconsistency that I'm concerned about.
Yeah, JC, I'm not a doctor, although my wife plays one, but let me just tell you that as I understand, say, the Plan B contraception, that prevents implantation of the fertilized egg. And so if there is conception as the law defines it, right, but not implantation, Plan B would prevent that pregnancy from even starting.
Mm-hmm.
Whereas once it's implanted in the uterus, then other things would have to happen. Somebody asked about Dormant Commerce Clause very quickly. That's just the doctrine that says Congress has all the commerce power, all the power to regulate commerce. States can't interfere with that. So a state can't make it illegal to do commerce with somebody from another state. All right. So those are the kind of general points. Let me flip very quickly to the gun case, because it's the same analysis, but they come out in a different way. Because in the gun case, they said exactly the same thing. Is something deeply rooted in history and tradition? Well, yes. The difference, though, they point out, is that the Second Amendment is written in the Constitution. So it's presumptively protected. That is, the right to bear arms is presumptively protected, and any regulation has to satisfy this historical test. In other words, any regulation would have to be very much similar to regulations that were in place in 1789 or 1868. Don't have to be identical, they said, but they can't impose any more of a burden. They can only impose a comparable burden on the right to bear arms, comparable to those historical burdens. And then they canvass history and tradition, and they go through and conclude, well, you know, the New York law that required a special reason to hold a concealed carry permit wasn't like anything that was going on in 1789 or 1868. Therefore, it violates the Second Amendment. So it's history only. Okay. Now, what is interesting about that is that in that case, the court said, well, you know, some history is more equal than others. And even though the states had shown there's a long pre-constitutional history of regulating abortion and regulating guns, they said, no, that doesn't really matter so much. What really matters is what was going on in 1789. So the promise of originalism, the idea that you can interpret the Constitution according to its original meaning, original public meaning, the promise was that that would be more objective, that you wouldn't have judges imposing their own values on the Constitution. The problem is this. It just seems to me that in these two cases, the court shows that it will pick and choose history. Even in the original 2008 Heller case, which created the right to bear arms as a personal right, you had two competing views of history. Each reached different conclusions. So if history is supposed to be more objective, then how do you square two reasonable interpretations of history that reach different conclusions? It's because history is not an exact science. It can only sort of predict and come close and approximate. The other thing that is troubling about this history-only analysis is that it really is inconsistent with the way we've interpreted our Constitution throughout. You know, one of my favorite cases is McCulloch versus Maryland. It involved the power of the government to create a national bank. And in that case, Chief Justice Marshall spends most of his time explaining how you should interpret a constitution, in relatively little time talking about why the bank is constitutional. And he concludes that a constitution is written in general terms because it's designed to last forever, and it's designed to adapt to the exigencies of the moment, that the framers were not all-knowing and they couldn't have predicted future circumstances. And while the basic principles may remain the same, the specific outcomes may not. So it seems to me that this history-only approach really does narrow and fold in to a tradition that has never been really adopted. The other point on history only is that the way the court in Dobbs reads history, it ignores one of its own cases. and that was the Obergefell case. So I think there's a real connection between the method in both these cases, the history, focus on history method, and in the sort of almost political nature of the outcome. One of the defenses of Dobbs is that Roe has proven so controversial and divisive that it's best to leave it to the states to make this decision by themselves. That was Justice Kavanaugh's concurrence. He says the Constitution ought to be neutral about such things unless there's specific text that tells it not to be neutral. That would be the Second Amendment. And he says, so being neutral means we just let the states decide on their own what they should and shouldn't do in relation to abortion. The dissent's response to that is, you've chosen a side. That's not neutrality. Neutrality would be to say people are free to choose, make their own decision about whether or not to have a child. And that's true neutrality, not a neutrality that takes a position on what is a controversial public issue. Okay. So again, there's a lot more there, but that's just the basic stuff. So, hey, Terrence, do I have any?
Yeah,
Terrence, do I have any questions?
boatload. Well, there are comments. One comment that you might want to address is there is a concern that views that differ from the views you articulated are have not necessarily been represented in your remarks. So, you know, if you want to speak to that, speak to that. So
Sure. Well, I guess I can say without trying to be too flip that these are my remarks, and they are based on a career of studying this stuff and a career of studying and reading and thinking about it. And so I think the views of the majority are pretty well represented, but this is my critical analysis. And a critical analysis means that you show that the roots and the problems with the analysis. So I don't want to shortchange people, but again, this is my conclusion based on a long study. I will confess that I've always been skeptical of substantive due process. And I was originally skeptical of Roe, but I think Casey is the better decision because Casey grounds the right in a host of other rights. A host of rights to make decisions about who you are and what you can do with your body, very autonomy, personal autonomy. And to me, that's a much more solid foundation for the right to choose an abortion than some amorphous right to privacy that Roe talked about. The problem is, I think it's like, as I said before, like Jenga. All those rights are together in one ball called liberty and personal autonomy. And if you pull one out, the rest fall. So I think Casey is the better decision. And I think pulling out abortion threatens the structure of all the others. What else?
there's a question about why intermediate scrutiny doesn't apply to the issue through a lens of sex distinctions.
Yeah. Two steps to that analysis. One, the court said that previously they held that regulation of reproduction was not by itself a discrimination based on gender. And so those things have always been treated to this rational basis review. So the fact of pregnancy doesn't by itself create a gender classification. Now you can disagree or not, but that's what they said. So the second step then would be, if that's true, then even if regulation of abortion is in some ways a gender classification, it's not the kind of gender classification that would get this intermediate level. So they drop it all the way down to rational basis. And I guess there's a third reason, and they say, in any event, abortion always involves a second interest, that is the interest of the fetus. And in that way, it's different from all the other rights, including pregnancy regulations. Someone did mention about preserving an unborn child's life is not a radical decision. Of course, it's not. What's radical is the nature of the court's analysis. It seems to me that what the Casey and Roe era did is they said to people, you're free to make that decision without state interruption, without state intervention. You're free to make that decision all you want. We're just not going to intervene here. I think that's the key issue. What's radical is the court changing the way it thinks about the Constitution in ways that, frankly, remind me of Dred Scott, the infamous decision where the court ruled that slaves and their ancestors could never be American citizens. And they used the same kind of historical reasoning in that case. And they said the same sort of things, you know, look, this is a policy question. We think slavery is terrible, but we can only interpret the Constitution the way the people who wrote it meant it to be read. And they didn't mean it to include slaves and their descendants. Now, they were wrong on moral and legal grounds, but it's the same theory. And if history is the touchstone, if history is the keystone, then history is not infallible. Well, let me just talk about the gun case again for a second. The court does all this history, right? And they did history back in 2008. But there have been very important scholarly studies by historians that show the court got its conclusion wrong in 2008, historically. So does that mean that the court now will change its mind when there's better history? That doesn't make sense. The Constitution is about a set of values. It's not a historical project. The Constitution established a set of values. Those values are permanent. Their application is going to change in new circumstances. But if we insist on interpreting the Constitution the way it was written, or the way we think it was meant to be understood in 1787, we're not going to be right. We could be easily wrong as we are right. So while history is important, it can't be the only thing. Terrence?
There's a question about just the Chief Justice's concurrence.
Okay. Well, here's the deal. The Chief Justice, when this case first got to the court, that's what I thought the majority opinion would be. I thought the Chief Justice would say, listen, viability is an arbitrary line. It was an attempt to balance the interests of the fetus and the woman. But Casey said that the law prohibited states from imposing a substantial obstacle in the path of a woman. And so if statistics show that about 95% of abortions happen before the 15th week, then he concludes women have had a substantial opportunity to choose abortion, and the state should be able at that point to impose its interest in fetal life and stop abortion. Now, I thought that would have been the outcome. What changed was Justice Barrett being appointed to the court, basically, because that changed the calculus from 5 to 4 to 6 to 3. So in some ways, Justice Roberts is, I wouldn't call him a supporter of Roe. He's an incrementalist. He does support the decision. He probably would have voted to overrule Roe and Casey at some point in the future when there was a better case. He just thought at this point, we shouldn't quite go that far. And in some ways, this concurrence is kind of sad because he's the Chief Justice. You would think that he has some control, at least historically that's been true, over the court. But it's pretty clear that in this case, he had no control over his opinions or the outcome. And no one joined his opinion. It was just his solitary voice.
There's a question that if a person is harmed as a result of being compelled to carry the pregnancy to term, could there be a cause of action against a state whose law compelled carrying the pregnancy to term?
I don't think so, because essentially that's, now, let me back up. It could only be these extraterritorial situations, but even that's problematic. And so I don't think a state could pass a law that says, yeah, there's a tort for forcing somebody to carry their pregnancy to term if you're in a state that outlaws abortion, like Arkansas. I don't see what the basis would be. There is a question, I think, that's lingering out there, which is, could a state outlaw all abortions without exceptions, even exceptions for the life of the mother? I don't know. And if you believe, say, Justice Kavanaugh and Justice Barrett, that there might be some limitations, then I would argue that there's some due process right to life, right? Because the due process clause protects the right to life as well as liberty and property. And so forcing someone to sacrifice her life strikes me as a deprivation of that life without due process. Now, there might be some, again, limitations on it and what circumstances and how to define it, but I don't believe, it's hard to say what to predict the future, but I don't believe that would survive even in this Supreme Court, because it's such a severe deprivation. It's not just a minor, as they would call it, inconvenience. It's not a temporary dislocation. It's death. And the law does not require us to sacrifice ourselves for other people, even our children. So what else?
I was trying to go through the questions here. Under the rule of these two cases, could a state enact a law requiring everyone to be an organ donor?
Well, I don't think so. Here's why. I think they're likely to say that the right not to donate your organs is a right that's deeply rooted in our history and tradition. That even before organ donations, we generally didn't allow people to have their organs taken from them to be used for other purposes. And therefore, that aspect of the right of personal autonomy is protected by the Liberty Clause. So at least that would be my analysis. I think that would convince even conservative justices. And if you looked at history, I think that's true. We don't have any history of requiring organ donations. You don't have any history of requiring people to take their organs out. We have some cases that in the Fourth Amendment context, as Professor Kane knows, limit bodily invasions for the purpose of searches. So I don't think it would quite go that far. Lindsay Moss asked about the definition of protecting the life of the mother, and states have varied. States like Arkansas define medical emergency as only including a physical threat and exclude mental health. It seems to me that a similar argument that I made about deprivation of life could be made about these narrower definitions of medical emergency. I think it's a much harder case to make because I'm not sure that we have a history and tradition of protecting citizens' mental health. And therefore, if history matters, I think you could conclude that you can limit it to physical emergencies. And remember, it's only a rational basis anyway. So unless you can elevate it to some other fundamental right, like a right to life, it's not going to get much protection. Ashley, you politely raised your hand.
Good afternoon.
Hey,
May I ask a political question?
I may not answer it, but sure.
Okay, I'm not a lawyer, nor have I ever went to law school, obviously, but I'm curious to know what happens next as far as, women are going to be forced to have children, even if they can't afford to have children, and then those children will likely be on welfare and Medicaid and all the social programs. And generally speaking, I would say that a lot of the folks that are in favor of this decision are typically against social programs. So what comes next from this decision? We've created more babies, which is probably going to create more of a social welfare burden. What's going to be the next argument?
So, can you still hear me, folks? Because I'm having some trouble with all right, good. My video may not show. How about now?
Can hear you.
Okay, so here's the deal. It seems to me that the political question is like every one of those, and that is it depends on people to decide what they want their representatives to do. And I can certainly see a kind of pro-life agenda that built itself on prenatal childcare, postnatal childcare, a whole variety of other healthcare things. I don't know how likely that is. I think a lot depends on really the kind of political. So I think it's possible. I don't know that it's particularly likely in this environment. So I can't see anything because my screen is blanked out. So can you hear me?
Yes, we can hear you.
Looking at a totally blank screen.
At
So
least I can hear you. I don't hear anybody else except you.
that's a good thing. So can I answer anybody else's questions?
Dean DePippa, I did have more of a comment, but
Yeah.
kind of a question as well. I think one thing to consider in possible forced birth scenarios is how high the United States maternal mortality rate is. We have an absolutely abysmal rate of mother deaths due to birth injury in this country that isn't really being addressed either.
So I guess the answer there, and I'm going to borrow from some of the language of the majority opinion, is there are compelling policy arguments on all sides of this issue. And I think there's a compelling policy argument about maternal health, but those are policy arguments. Those alone couldn't sustain a constitutional right. So it goes back to the prior question. If there are any political developments, they're going to come politically through the ordinary process. But those policy arguments really don't say much about the nature of the constitutional question, at least in my view.
Right. Oh, I totally agree with that. I guess I was speaking more from a personal autonomy view and how scary, this can feel. Even if someone never wants to get an abortion, I'm someone who wouldn't. I'm at a place in my life where I want to have a child. And so that's not even what I'm upset about, but these are points to take into consideration with how we treat human beings. But I totally agree with you from the constitutional arguments.
Yeah. I mean, in some ways, Roe made it difficult to establish a kind of pro-life, pro-family liberal constituency. And I'm not blaming anyone. It just seemed to me that with the focus on preserving Roe as a constitutional right, it made it difficult to develop coalitions across party and ideological lines that could say, well, let's just take care of children. Let's put aside our other differences and just take care of children and families when they're born. And I think Roe, in some ways, made it very difficult to build that kind of cross-ideological coalition. So I am going to be, it looks like I'm going to be on channel 4 and channel 11 today. So anyway, I've got a couple more minutes and then I've got to head off to do those other interviews. So is there anything else anybody just needs to have spoken to? Okay. Well, thank you all for being here. And it's an interesting day when you can get a couple hundred people on a couple hours notice to sit in front of their computers or phones and listen to a talking head. So I do appreciate it. Thank you so much.